My name is Michael Fallings. I'm a managing partner here at Tully Rinckey. I focus my practice on federal labor and employment law, including representation on behalf of federal employees at the MSPB and the EEOC, and in both state and federal courts. I've represented employees regarding employment terminations, layoffs, RIFs, and so I'm happy to speak to all of you here today regarding the recent rulings on the reductions in force and what you need to understand and what you need to do going forward. So we'll talk about those rulings here today. Just to give more of an overview of what we're going to talk about, we're going to talk about the specific agencies that have been affected by the recent Supreme Court rulings, an overview of the reduction in force procedures. We're going to talk about what they are, what you need to know, what you need to be doing now, and then what you need to be doing in the future as well, as far as your case options are concerned. We're going to talk about what the ruling means, how to protect yourself as well, what documentation you may need to gather, for right now, so you can set yourself up as far as, leaving the federal government or potentially challenging that action that may be coming. And then when to seek counsel. We'll also talk about that. So we'll get started as far as just going over the Supreme Court ruling. So on July 8th, the Supreme Court of the United States ruled to allow or to continue the mass reductions in force to be implemented. So there was an executive order put in place to reduce the force of several agencies, which there then was a lawsuit that put a pause by a U.S. District Court judge on the administration carrying out those reduction in force plans. The argument was that the executive didn't have the authority to carry out these reduction in force plans, and that actually the congressional approval was needed. But the Supreme Court, in an unsigned opinion by the justices, stated that the government can proceed, or the administration can proceed in reducing the force of the government because the executive does have that power. There was just one dissenter in that opinion. Now, I think it's important to realize that the Supreme Court did not rule on the merits of whether or not a reduction in force would be allowable. The ruling was just that the administration can continue to move forward with its plans to reduce the force of the federal government or its reorganization plans. And that temporary pause was lifted by the Supreme Court. Now, Justice Ketanji Brown Jackson, like I said, was the lone dissenter. And, she stated in her dissent that, this would be unprecedented and it wasn't approved by Congress. But she was the only dissenter in that opinion. So given that ruling, several agencies have continued their reduction in force plans as far as reducing the size of the federal government. So just further about the Supreme Court ruling and overview of that, the executive order that I mentioned was first issued back in around February, that the case really hinged on, as far as President Trump issuing this executive order to allow government agencies, or to require that government agencies reorganize their workforce to reduce the size of the workforce. He wanted to initiate a large-scale reduction of force. Now, the labor unions and local governments and advocacy groups, asked the judge to prohibit the government from implementing this order, and that was granted. And there was a temporary restraining order put in place. So this is kind of what I was talking about as far as what led up to the Supreme Court order. And the U.S. Court of Appeals, denied the Trump administration's request to temporarily pause the order, which led up to the Supreme Court, ruling that we were talking about earlier this month. Now, during that time frame, the RIFs that were being prepared were on pause. So, federal employees knew that there were, a chance that they could be rep, but that was essentially put on pause. Now, there were some agencies that continued because they weren't part of the lawsuit during that time frame, but there were other agencies that were put on pause until earlier this month. So now let's talk about, I guess, just what a reduction in force is. If we go to the next one. Just a reduction in force overview. So a reduction in force is codified in federal regulations. A reduction in force has existed long before this administration, and it's been done in the past. But a reduction in force, or RIF, as is often called, is a separation or downgrade or furlough of more than 30 days, excuse me, or more than 22 discontinuous calendar days. There's specific procedures that the government has to follow to reduce force. There's specific requirements that the government has to meet as well. But the government has to show for reduction in force that it's required and necessary due to a lack of work, or short of funds, insufficient personnel ceiling, or the exercise of certain reemployment or restoration rights. The government has the autonomy to decide whether and when a RIF will take place and what positions are abolished. A government could avoid a RIF with reassignment of employees or whatnot, but for this purpose, this administration has decided that a RIF is necessary, due to its stated goals of wanting to downgrade the size of the federal government and wanting to reorganize the federal government. For a variety of reasons that the administration has put out there. But just because it's their desire, they still have to follow the regulations that are codified in the federal regulations, part 351. And we'll kind of go through these requirements and these factors. So on our next slide, we talk about the main factors that need to be taken into consideration by a federal agency when reducing force. And those are the tenure of employment, the veteran's preference, the length of service, and the performance ratings. Now, when a federal agency is conducting a reduction in force, they consider these factors to create a retention register, which is essentially a ranking of employees in a competitive level after applying these factors. So the agency is considering, well, how long the tenure of the employment and the type of appointment that person has, their length of service, whether there's a veteran's preference, and performance ratings to, again, rank those employees within the competitive level. What the government also has to also create is a competitive grouping where, in reductions in force, the government will group employees together based on the type of job duties they're performing. Now, what may be the case in some agencies, I know in recent reduction in force by this administration, for example, the USAID, the government essentially said, well, we don't have to conduct the competitive grouping because they're reducing the entire agency. Now, with the agencies that are going to be reduced in force potentially as far as this ruling, that will also be an important factor, though, because those agencies are still going to exist. For example, HHS or Department of Veterans Affairs, the government is going to have to create a competitive grouping where they are classifying employees based on the job duties they're performing and then ranking them according to these retention factors. Again, that are listed on the screen here: the tenure of employment, the veteran's preference, length of service, and performance ratings. So based on these factors, it's important for employees to, one, understand these factors, and then understand, how they could potentially rank as far as in the retention register. As far as performance ratings, that's, gathering your performance evaluations and ensuring that your performance evaluations are accurate as listed in your personnel file. Ensuring that your service computation date, when you began service with the federal government, is accurate as well. whether you're classified as correctly, on your SF-50s or whatnot. So overall, getting your personnel file and reviewing it with the fine tooth comb, really, to ensure that all your documents are accurate or in place. Because when you receive a notice, it should list the reasons why you are being reduced in force, how you fell into this retention register, and then it will list, what your performance ratings are or whatnot. And it's important to review that notice because we've even seen some, errors in that notice. And so if you're able to have that documentation to prove that, that your performance ratings are listed incorrectly, or your classification of employment is incorrect, that would help you kind of challenging that reduction in force notice. But just knowing that, these are the factors that the government needs to consider, as well as like I've mentioned, the, whether or not you're in the right competitive grouping, and when you receive that notice of a reduction in force, and we'll talk about this here soon, is contact your Labor and Employment Relations Department to ask for information regarding how they classified you. Why are you part of this reduction in force? What information did they use? Where did you fall on the retention register? That's something that you should be asking as well, because if that information is incorrect, or and there's errors that they're not willing to fix, that may be a reason why you would want to challenge that reduction in force. And we'll talk about further how you could challenge that as well. As far as further on the reduction in force process, so there's definitions that the government does use to, evaluate employees as far as who should be subject to a reduction in force. And I've kind of discussed some of these, but the local commuting area is essentially where the employee lives and can reasonably commute to. And then the competitive area and the competitive level, it's established those geographical and organizational limits. So one thing, in addition, if you're an employee that's potentially subject to a RIF, is to obtain is an organizational chart. And an organizational chart could be important because you could learn whether or not you are being in the same competitive level, the same competitive grouping, as I've been stating, as other employees, and where you fall on the organizational chart versus other employees that may be RIFed. Because if you're being RIFed, but you discover that other employees that are being RIFed are part of a separate organization or a separate division on your organizational chart, that could be an issue for the government, that you could use that to challenge the action. So as we stay here on the screen, it could consist of anywhere between the entire agency or the local commuting area at least. So like I was saying, that other agencies that have gone through RIFs, they've classified the competitive area as the entire agency, which makes it more difficult for that employee to challenge the RIF as far as whether they're in the right competitive area. But I would anticipate these agencies that are now doing RIFs aren't going to be reducing the entire agency. So this would be more relevant. And then competitive levels, again, these are groups of interchangeable positions. The positions within one competitive level share the same grade, series, official tour of duty. So those are important factors there as well. Kind of what I've been emphasizing is whether or not you're in the right competitive level. So again, the government has to go through a process to determine who is going to be laid off, who is going to be reduced in force. And the government has to essentially group employees based on their positions, and then what level they're at. And the positions in one competitive level need to share the same grade, series. They have to be comparator employees, and it could be an issue if these employees are not comparator employees, like I've been saying. They share qualifications, duties, and responsibilities based on their position descriptions. So that's another document I think that needs to be obtained if you don't already have it, is your current and official position description. that will be on record about what job duties you're performing, and there won't be dispute about that. And that's what the government should be using to determine your competitive level, and not the experience or expertise of the individual holding the positions. The positions could be placed in the same competitive level when the position descriptions for the two positions that an employee has and are similar, and they need no more than 90 days to perform the task. So I think another document to look for, if you're being subject to a RIF, is your performance plan, and again, your performance evaluation, because that would also detail what job duties you're actually performing. And if there's actually a discrepancy between employees that, I've had experience with some employees that are performing certain job duties that are outside of their position description. Well, that's why it's important to get your performance plan as well, to show that these are actually the job duties you're performing based on what performance plan you had for the year. But again, all this is important, again, because this is what the agency could use to, determine whether or not you should be RIF'd. So as far as challenging these RIF actions, one of the main methods for employees to challenge it is through the Merit Systems Protection Board. Per federal regulations, a competitive employee could appeal to the Merit Systems Protection Board. Now, that appeal needs to be filed no more than 30 days from the effective date of the RIF action. And that's important because you'll get a RIF notice, and the notice has to be sent actually at least 60 days prior to the effective date. So you can't appeal prior to the effective date of the notice. So when you receive a notice, you have to actually look for the effective date before you could actually appeal. And so the Merit Systems Protection Board is a federal agency that adjudicates RIF actions. This agency has administrative law judges that could review the appeal, review the RIF action, and determine whether it is, accurate, whether the government actually, subjected you to the RIF properly. A question I know I've been getting, I believe we've already received even before this, is, well, I've heard about the MSPB. I know they're really busy. Should I still go to the MSPB? Well, and then the MSPB doesn't have a quorum right now. Well, there's still administrative law judges. Yes, there's been an uptick, but from my experience, they're still processing these cases. And if you go through an MSPB appeal and a judge rules against you, you still have an opportunity to file a petition for review, which is essentially an appeal of that decision. And you could appeal that to the Federal Circuit Court of Appeals, which is outside of the MSPB. So there's still a process to challenge that. And that may be the only way you may be able to challenge this RIF action. I do still encourage employees under those circumstances, when it appears that you should, to file those MSPB appeals. So that is the main way, and it is allowed via federal regulation. The burden of proof there is treated as if a RIF were an adverse action. And as we'll talk about here soon, is that the agency actually has the burden of proof to prove that they conducted a proper RIF. So note that the agency actually has to prove to the judge, even though you're appealing, the agency actually has that initial burden to show that they, went through the RIF procedures like we've been talking about. Like we have on the screen, a negotiated grievance procedure must be used when an employee is in a bargaining unit that does not exclude RIF. And then we also talk about discrimination here. So what all that means is, essentially, if you're part of a union and you are under a negotiated grievance procedure pursuant to, a CBA or whatnot, you should follow those procedures to challenge the RIF. If you believe that discrimination is involved, or retaliation is involved, that could be a potential avenue. I think that may be more difficult for RIF actions, given that this is affecting a large number of people, and usually those type of actions are more individualized as far as discrimination and retaliation actions, but those are also options for you to challenge those actions. As far as appeals are concerned and just the burden of proof there, as I said, the agency does have the initial burden of proof that it conducted a proper RIF. It has to meet those criteria that we've been talking about as far as the RIF procedures are concerned, outlined in the federal regulations, and showing why a RIF was necessary, whether it be due to lack of work, shortage of funds, reorganization, or so on. So the agency does have the burden of proof. Now, the agency, if they follow their procedures, it shouldn't be that onerous of a burden to meet for the agency if they follow those procedures. As far as classifying you correctly, showing that there was a need for a RIF, and then the burden would shift to the employee then to prove that the RIF was not conducted in a proper manner. So on the next slide, we talk more about that. And once the agency presents that evidence that to establish the RIF action, it does fall on the employee then to prove by clear and convincing evidence that there was impropriety with the agency's procedures, and there was an error in the RIF process. One of the ways, and on the next slide here, we could show one of the main ways to challenge the RIF. But one way is to failure to provide adequate notice. So like I said earlier, the regulations provide that and require that employees are entitled to specific written notice of at least 60 full days. So again, when you receive that notice, it should give you at least 60 full days before the effective date of the action. And again, you have to wait for that effective date to appeal the action to the Merit Citizens Protection Board. But if you're not receiving that 60 full day notice, that could be the procedural issue. And my understanding is I know some employees already have received notice and been laid off. So that is something that those employees should look to challenge if you haven't received that 60 full day notice of the RIF action. Failure to be placed in the correct competitive area. Like I was kind of saying and emphasizing that the government has to place you you have to be correctly classified as an employee to be RIFed. So one thing they have to prove again is that you are in the right competitive area, which I think in some essentially means that you're in the correct grouping of employees, where those employees are performing similar job duties to you, or in the same organization, same work function, same staff, and that's what that regulation states. And now the next one, another way to challenge it is whether you are in the correct competitive level, whether you're correctly ranked in that retention register. And on the retention standing. So, and that goes back to some of those factors we talked about earlier as well. And then just comparing yourself to other employees in that competitive level. And just, some of those factors again, as far as challenging the retention standing is, your performance ratings, your tenure of employment, your length of employment, whether you have veterans preference or not. Those are things why you want to gather those documents ahead of time so you know whether to file an appeal. Because if it appears that you don't have an opportunity to file an appeal, or the government did follow these procedures, then now what your chances are. But if you don't have enough information, if you haven't been receiving the information, you do already note errors in the RIF notice you received. These could be reasons why you want to move forward with an MSPB appeal to challenge, that RIF action. So on the next slide, we talk about the MSPB jurisdiction, and we talk about here how the MSPB ordinarily lacks jurisdiction in review of voluntary reassignment to avoid the consequence of a RIF. But the more closely a reassignment process resembles the execution of a RIF, the more likely the reassignments would be considered as part of a RIF. So what this all means is essentially, and it was referenced earlier, that an agency could attempt to avoid a RIF by reassigning an employee to a separate organization. But there is still an opportunity, especially if the employee doesn't agree with that, to potentially challenge that reassignment action because it was done in lieu of a RIF. And the employee may still have an opportunity to challenge that that reassignment action if it was in conjunction with the RIF. I'm not sure how often that is happening currently, but that has happened in the past, where employers are actually just reassigned when it's actually in effect a RIF, or they're being, just changed to a different position. But normally, the board does lack jurisdiction over a transfer to another agency done after a RIF is notice is made, unless it was, you could prove there's evidence that it was actually a RIF or was done involuntarily or whatnot. So I think the main point here is the main point of jurisdiction is a RIF notice. And when you receive a RIF, there may be jurisdiction if you've been reassigned to a separate agency or reassigned in lieu of a RIF. Now, I think, it's also important to note that there is still ability to appeal when your reemployment rights have been violated. So when you received a RIF notice and you've been RIFed, you do have a right to be reemployed, and you have priority there, and that should be detailed out in your RIF notice and when you're RIFed. And if those rights are violated as well, there is an opportunity to appeal. So when to seek counsel? I think it's important to seek counsel when you feel, especially when you feel you're not understanding, the process, when you received a RIF notice and you're not obtaining the documentation on your own. I think, our firm has represented many employees that have received RIF notices and given them advice and assistance during that 60-day period to obtain the documentation, to ask the questions, and that will set them up for an MSPB appeal. So I think even before your right to challenge this action, I think even once you receive that RIF notice, I think even now, even if you haven't received a RIF notice and you're concerned about, well, what may happen, am I, being correctly classified, that could be an opportunity. But certainly, and of course, when your effective date runs and you believe that you haven't, there may be an error in the processing of your RIF, to retain an attorney and file that MSPB appeal. Just ensure that 30-day deadline, like I mentioned, that you have 30 days from the effective date to file an MSPB appeal. So I think it's abundantly important at that stage, after you receive the RIF notice and your RIF has been effective, but before the 30 days is over, to file your MSPB appeal. And that's a good point to retain counsel. So I'm going to go through some of the questions that we've received even before this presentation, and I'm happy to answer any questions that people may have as I've been speaking as well. So one of the main questions I was seeing before this was about Health and Human Services. And the reason for that question is because there was a ruling out, I think in Rhode Island, that still had an injunction in place. But my understanding is that HHS employees have still been laid off and still received RIF notices. I don't believe HHS was part of the July 8th Supreme Court ruling. And so I think the Rhode Island case that was still in place, that injunction that prevented those RIFs, and the government moving forward and still laying off those employees, I think those employees have a good basis to challenge those actions. I think there's been several employees that have received notices earlier this week that they were being laid off. And even though the Rhode Island case was still in place, and I think those employees should continue to challenge those actions. And my understanding is that those employees were immediately laid off, without even the 60-day notice. I think for the reasons I've kind of gone through this in this presentation, I think there could be procedural issues with that. And, I would advise those employees to consider retaining attorneys to challenge those actions with MSPB. So as far as just, I've received questions just about, the, what, I guess, benefits are available after a RIF. And, there is severance pay available. there is priority reemployment rights available as well. And those are things that are stated in the Code of Federal Regulations as well. So a RIF is essentially a layoff, and it is something that is not the same as a misconduct removal or poor performance removal. So it's not preventing that employee from being reemployed. It is adverse in the sense that that employee is being terminated, but it's not in the same sense that employees being terminated for cause necessarily. So there's still benefits, like I said, severance pay and reemployment rights. Employees could still be reemployed to the government if they still desire. Getting questions about just like asking it for job descriptions, organizational charts to your personal email. I usually don't advise trying to put stuff on your personal emails or anything like that. I think through your government emails, but if you have already been removed or whatnot, you could certainly, and you don't have access to your official government emails, you could certainly reach out to, your labor and employment relations departments to obtain those documentations. So getting some specific questions that I think, it may be easier to answer through a consultation with an attorney or whatnot. So another question we just got is, how long do you anticipate it will take to appeal filed mid-August for employees? So I think this question is essentially asking how long it would take to appeal, or how long the appeal process takes, perhaps, for the MSPB. So the MSPB goal is to adjudicate cases within 120 to 180 days. Now, I will say often there are cases that get extended through case suspensions and whatnot. But when I say adjudicate, meaning get to a hearing and have a judge rule on the appeal, and that's without any extensions or whatnot. Now, there has been an uptick in cases. The judges are busier, but I know the goal is for the MSPB to still try to move and process these cases as quickly as possible and to hold a hearing. And I guess just to overview on the MSPB process, just to be more specific about that, that means filing an appeal. Then the government has a chance to respond to your appeal, and they submit what's called an agency file. And then the judge would perhaps request written submissions on jurisdiction to confirm that the MSPB has the appropriate jurisdiction over this RIF action. And then after that jurisdictional process, the judge would allow a discovery period. Sometimes judges won't require that jurisdictional requirement, and then they would allow just a discovery period. A discovery period is asking the government for more documents, or asking specific questions, written questions, what they call interrogatories, or even perhaps taking depositions of individuals. And those depositions are oral interviews of witnesses under oath. Now, the government can ask questions and ask for documents from you as well. And then the judge would hold a hearing, which is a hearing where you have the opportunity to testify and relevant officials. Now, you're not required to have a hearing. You could ask for just the decision based on the written record. That would be up to the appellant, which is the employee, to decide. And like I said, the judges, I know we're trying to get this as quickly as possible. In my experience prior probably to a lot of the uptick, it's, you would receive a hearing and have a decision at least within 6 months or so. But there are exceptions to that. There's definitely cases that are extended out, but I do know that the judges are still trying to process these cases. And then, like I said, after that hearing, you would receive a decision, and then you had an opportunity to appeal what's called a petition for review further through the federal circuit or even to the board, the Merit Citizens Protection Board. I received another question. It was a little bit more specific, but essentially someone has received a separation date of a RIF in April, a separation date in June, but they're expecting another notice. And then I guess the question is whether employees should file individual appeals or file class actions. Now, I think class actions have been started to be filed, and I think that is, I know MSPB judges are accepting those. Now, keep in mind the MSPB has to accept the an appeal as a class. So, and a class action could be filed if the appeal is if the appeals are related, and it's against the same agency, of course, and the issues are so similar, in fact. But if the MSPB judge accepts that as a class, then that could proceed as a class. To the extent, so what I would advise, employees at this point is if you are trying to file together, you could initially file as an individual, and you could file your individual appeals and then request that the judge group them as a class appeal with the people that have also filed. And I say that because there may be different dates or whatnot when people may need to file. And so just to ensure your rights are processed. But if you already know and you already have a group of employees that are seeking to file, then you could try to file as a class and request in your appeal that this be classified as a class MSPB appeal. And I guess another question is, would you be prevented from participating in a class if you've already filed an individual appeal? Not necessarily. You could ask the judge to bring you into that class appeal as well. I'm getting questions about just severance pay for military retirees. I think that's more of a specific question that I think we'll have to, answer through a consultation. So going back to the class, and we're getting a lot of questions about the individual versus appeals versus a class appeal. If you are not certified as part of the class, then you need to file your appeal, especially if your deadline's coming. You want to protect your rights. You want to avoid a judge saying this class is not certified or whatnot. So you need to file your appeal if you're not certified as part of that class. And yes, if you aren't part of the class and you haven't submitted your appeal, yes, you could submit your own appeal. And the reason for that as well is you may have different arguments about why the RIF for you was different than the class. As far as retirement is concerned, if you're eligible for retirement, yes, you're eligible to opt for retirement. OPM has certain regulations for retirement, and you typically want to try to retire while you're on the rolls. If you don't have that opportunity, you're still permitted to retire though. And when I say on the rolls, meaning before you're actually riffed or before you're actually separated. So I believe those are all the questions we've received. And again, I'm just looking over any other questions that I potentially didn't answer. A lot of the questions we received before were regarding that Health and Human Services issue, which I talked about. But as I've said, throughout this presentation, it is important to obtain, the documentation I laid out. Some of the main documentation I've talked about is your position descriptions, organizational charts, performance evaluations, verifying that you're classified correctly in your position, verifying that your length of service is correct. So just your entire personnel file, your performance documents as well. And if you've already received a RIF notice, asking your Labor and Employment Relations Department to obtain those documents, as well. And then understanding that you have a right to challenge the action through the Merit Systems Protection Board, which is the main method there. And then understanding that, yes, you're going to be entitled to severance. You're going to be entitled to reemployment rights as well, even if you do not try to challenge the action, or even if you do decide to challenge the action, you're still entitled to those. And we just got some additional questions. As far as the Department of Veterans Affairs, my understanding is yes, they are, still planning to go through that RIF. I don't know if I've seen any update on that, but my understanding is that was a plan there for the Department of Veterans Affairs to be reorganized. And as far as a grievance or an MSPB appeal having a more likely outcome, I can't necessarily say which one is more likely. It really just depends on the facts of your case. I think the MSPB is the standard method that individuals are challenging it. A union grievance would be through your union. And I can't speak to how well that would go because that could be based on your collective bargaining agreement. As far as our consultation, the firm does offer consultations. We do, offer consultations for this issue. We have plenty of attorneys at our firm that have been consulting with employees that have received RIFs or scared about receiving RIFs. Contact our firm, regarding that consultation. I think we had our information there on the screen there. On how to contact our firm. We have offices, throughout the country, including in, Texas, Washington, D.C., and New York as well, in California. So, please contact us, regarding your specific employment situation. And just getting a few more questions here. So any intel on whether the EPA will proceed with the RIF? I don't have any intel on that other than my understanding is similar, that they are still going to proceed, with the RIF as well. And let's see. So as far as getting a lot of questions on just union collective bargaining agreements superseding RIF policies and executive orders. I think this has actually been an issue that's been being litigated or challenged between, the administration as far as what power it has over whether their policies supersede. But the federal regulations, are meant for the agencies to follow those. But I think all of that is being litigated about what power the administration has to supersede potential federal regulations or just, union agreements. So indefinite exemptions change the competitive area. So, I mean, that's a difficult question to answer. I think, there's not necessarily things that are going to change the competitive area, but that's going to depend on what comparative area you're talking about. What type of employee you are, where you are in the organization as well. How do you know if you're part of a class action? Well, you should have received a notice. If you're part of a class action, you should know that. If we haven't received a RIF notice in the mail, should we assume we've been RIFed? No, you need to receive a specific notice, and that means you received it. And so, if you've gotten just an email notice, I think you need to respond and clarify to, your supervisor, LER, whether you're part of a RIF or not. Yeah, and so I just got a question about the Health and Human Services, and we're still just getting questions coming in. But as far as the Health and Human Services are concerned, that they RIF the entire competitive areas. Well, that's something that I know other agencies have done, and so that's why they're trying to avoid doing those retention registers or just the entire level. Now, they still have to rely on those factors. So just because if they're saying they removed an entire competitive area, doesn't mean that you cannot challenge the action. You still have to look and see whether your service computation date was correct, whether your performance ratings were correct, because that could depend on whether or not you're in the correct competitive level. And I think that's something you should contact an attorney to discuss further, to determine whether or not a MSPB appeal is viable. And again, our information is on the screen here to, request a consultation with our firm. And then, again, we could offer representation for you during your challenge into that action. Okay, well, I think that's all the questions we're getting that I guess are overall relevant. Again, I know there's probably some very specific questions based on your personal situations that are hard to answer in a group setting. But I think that's why our firm has been offering, not only these webinars to give you this information, but our attorneys are able to talk with you individually about your personal circumstances get the RIF notice or the emails or whatnot you've been receiving and talk with you to determine how to properly proceed. So, I do encourage you to contact our firm, to set up your consultation, and then so we could go through your situation and determine how to proceed. But with that said, I'd like to thank everyone for appearing for today's webinar. Hopefully this was helpful for you. And I encourage you to contact us, for further questions about your matter. But thank you.